Okay, ladies and gentlemen, good afternoon. And I am not David Wilton, but he sends his regards. He's teaching today on behalf of the program in the legal profession, and David and the whole staff and team here, and Hakeem Lakhdar, who administers this program. Welcome to another student speaker series. Today we have Joe Macrae and Daren Wein, both of Mlegal Consulting on the West Coast. Both have extensive experience in professional recruiting of law firms. Joe oversaw the growth in the business from a startup to a 60-person plus recruiting firm. Daren, who focuses his practice on partner-level firm searches conducted in the United States and internationally, with an emphasis on strategic law firm expansion in California, England, and Asia. I think this offers us a great opportunity and the insight, certainly post-2008, where the legal industry is going on the West Coast and globally, particularly since Joe has worked in London as well and started a firm there. So I hope we gather some insight on where the trend is heading, what it might look like for many of you when you get out. And please, they're open to an interactive engagement with you, so this is not a one-way discussion. Welcome, Joe and Daren.
Thank you very much. Thank you. So I'm delighted to be back. This is my third visit. It's already going better than the first two because I think we've got at least 4 times as many people. So obviously you didn't get the feedback on last time. And because our talk is titled Silicon Valley, we thought we would dress appropriately. So let's go. It's the first thing that happens when lawyers come to Silicon Valley is you can immediately judge the guys who are coming for the first time and the guys who've been there before, because the clients just think you're from outer space if you turn up in a suit and a tie. The other thing before we get going is I understand that your timetable is you've got to be out of here by starting around 1:15. And having watched a number of the presentations you've received in this slot, we've kind of observed that a lot of them follow a formula of people talking about their slides and then occasionally leaving you time for questions. So that's kind of boring for us, so I can't imagine how boring it is for you. So I would encourage you to interrupt us as often as possible on the way through. And also, when we start the slides, we'll just show you kind of what we want to talk about. And obviously, you know what you're studying and which bits of this might be even vaguely interesting to you. We're hoping some of it is, but if you wanted to start at the end and go back to the beginning or whatever, then please tell us. And just to complete the introductions, yeah, I've been doing this since 1988, which is pretty sad. Daren has worked with me for over a decade. And I've also brought my daughter, Amy, whose job is to count the number of times I say or literally, because I have strict rules on her and her 3 sisters on this topic, and so I'm hoping that I can set some sort of an example. So let's begin. Do you want to deal with that, and then if it goes wrong,
then you can blame someone?
Yeah.
All right. Coming up.
Okay, so the things that we're going to talk about, the 3 circles is sort of the definition that all of the corporate lawyers in Silicon Valley use to describe the kind of cradle to grave industry of companies. And then there's a chunk of stuff building up to the first boom, so sort of the history of how law firms developed in Silicon Valley. We consider the first boom to have been sort of mid-90s up until about 2000, Amazon going public, and the first stages of people taking equity in clients. Then the boom itself, and then of course the bust, which was just as I set up my recruitment company in Silicon Valley. So don't ask me for stock tips. And then the build up to the second boom, which we consider to have started sometime probably around 2010. And we've got some predictions on when it's going to end. And then the hot practice areas. So for those of you that are thinking of a career in Silicon Valley, the things that are currently of greatest interest for law firms there. So before we start, is there anything that people would say, well, this is kind of right on point for what we're doing? Please talk about that first. Or should we just wade through it and take your questions?
Or just wait till they finish eating.
Okay, so absent that, we'll wade.
All
okay.
Right. Early.
So
this is our office.
That's probably one of the most iconic images of Silicon Valley, which, for those of you who don't know, is the HP garage where it all started. And trying to make these things topical, I was reading the Financial Times last week, and this just struck me as an unbelievable statistic about how Silicon Valley has the capability to go bonkers and then go bonkers again. And I'm not very good at math, but it took me a while to confirm that the Tesla number is 20,000 cars sold last year, and their market cap is half the size of General Motors. And you've got the stats.
Yeah, if you look at
half the size of Ford. Yeah.
Yeah, if you look at last year's share price, $39 for Tesla. Yesterday at close, $252 for 20,000 cars sold. Now, you may not see a lot of Teslas around here, but we sort of view the valley as an ink blot, where the ink radiates outward. You can't drive a block without seeing 3 Teslas in various colors on Sand Hill Road. And there's press out there that suggests there are certain little enclaves that have adopted it. It's not a cheap car, but the idea is that electric cars clearly have made their way, and high-end electric cars are selling.
But I put it up just as an example of valuations gone mad again. And people are still saying Tesla should be a buy because of the idea that perhaps someone like Apple's going to acquire it or whatever. Anyway, back to the more mundane issue of law firms. So I first heard of the 3 circles back in the early 90s, and Larry Sonsini, who's probably the father of law in Silicon Valley, used it to demonstrate to incoming lawyers, I think, how he saw the Valley working, and divides it between the early stage companies about which you hear so much, the pre-public companies where they're being groomed, and what they need to look like to go public varies dramatically depending on whether it's the first or second boom, and then the public companies, which the traditional law firms salivate over because that's how they know how to make money. This is our, all graphics, by the way, were done by our 23-year-old intern, who assures me that they're amusing. So the credit goes to her if they are. So you'll see that the firm names in the different circles are different. And there are certain firms in the early stage circle, like Gunderson, which are famous locally and indeed nationally, as we'll come back to later, as being just a firm that does really good work in the early stage market. Obviously, Wilson Sonsini is the grandfather of that market. And then Latham is really the only global elite tier 1 firm that we have that is strongly established in that market.
Yeah, and I think if you take a look, you'll notice you'll notice that the mid firms. I don't know that anybody would go out of their way to say Kirkland is a pre-public, but everybody knows them more as a private equity master. The early stage firms are going to succeed in the Valley largely because they have a rate structure that allows for it, whether it's taking equity, we'll get back to that, or just simply can accommodate startups that can't pay a whole lot of money. Go to the other end of the spectrum, it's not that Davis Polk's going to be able to accommodate someone at a couple $100 an hour. Paralegals don't even bill at that there. But Joe's right, Latham is one of the few that has found a way to cover all 3. And in the midsection, what you're also going to find is different firms have infiltrated different industries, but don't necessarily handle them all. So Covington would be a great example of a very strong firm in life sciences in pre-public, but not necessarily on the tech side.
Okay, before you go to the next one, for those of you who don't know, Hakeem is a highly accomplished musician, and so this was in his honor and for my amusement. So when the law firms were looking at Silicon Valley from San Francisco in the probably late 70s, early 80s, they kind of looked and it was down there and it was a bit different and it was weird. And so they had a choice. Do we go from San Francisco and set up in Palo Alto, which at that stage was still sort of 25,000 people and a few tech companies, or do we go to San Jose, which is a town with railway stations and structure? And so what's really, from a historical perspective, extraordinary is that Gibson, Dunn, Orrick, Pillsbury, all of these firms thought, right, we're going to tackle Silicon Valley, we'll go and set up in San Jose, which, according to the barman last night, would be saying, we want to tackle the Cambridge high-tech market, and they go and set up in Belmont. So it was just wrong. They then moved to Silicon Valley as they realized that it's such a kind of insular and quirky place that the tech guys in Palo Alto thought that if you were coming from San Jose, you might as well be in Los Angeles. And so the firms concentrated very rapidly in Palo Alto. The Southern Californian firms arrived next. And as you will have seen from our previous slide, the rest of the country has arrived over the ensuing 10-year period to a point where there are now probably 100 plus of the ANLAW 200 with offices in Palo Alto.
Yeah, there's a continuing question about where to set up if you're really late to the party. Is it San Francisco or Silicon Valley, Palo Alto, and the handful of towns around it? The life sciences corridor is about 5 miles south of San Francisco and about 20 miles north of Silicon Valley. So you still see a lot of folks asking themselves, should we set up in San Francisco because maybe this is the area that we're going to try to target. But 80+% of the arrivals still are looking for space in Silicon Valley, which is one of the reasons why you can't find commercial space in Silicon Valley.
Question.
Yeah.
Are firms attempting to move up those circles? Is that aspirational? Or are they carving out a niche and becoming so specialized within their particular circle that they actually try to get more profitable work within the circle?
So we've got so frustrated with trying to answer that question for law firms that my colleague Martha and I wrote a paper, which I'm happy to send you, about why it is that most of the law firms are wasting their time trying to set up corporate practices in Silicon Valley. Because the traditional firms, Wilson and Cooley, have robustly held on to their market share over the last 10 or 15 years, despite all these other firms arriving, largely because they have this first circle practice. So Wilson has, I'll get the numbers slightly wrong, but it's either high 20s or low 30s% of the startups that come through Silicon Valley. That's a huge market share. And so it feeds their second circle and third circle practice. So clearly that is a model. Other firms that have come in to try and replicate that, I don't know if we can go backwards, but if we go back to the first circle, very few of the out-of-town firms have been able to come in and say, we don't do first circle work anywhere else, and startups are kind of weird, and we know you defer fees, and we know you take equity, but we're going to do that in Silicon Valley, and we're just going to embrace it because we need to. Latham have done that spectacularly well. Gunderson have done it well. But many, many firms have either dabbled in it and failed or just can't get their head around it.
Yeah, the other piece, just to follow up, is that it's a numbers game. So many of these startups will fail that you have to have enough in the first circle to get you to the second, to get you to the third. And hiring one or two partners when you come to town doesn't really give you the numbers to succeed, so you have to keep hiring. And one of the challenges in the market is that as famous as the Silicon Valley market is, the number of lawyers is a fraction of what you'd see in New York. So there's a dearth of talent that they can draw from.
So the two other quick responses to that are, there are a number of firms who have come in with what we call a skimming strategy. So we are Davis Polk. If you need the highest end, most sophisticated services, we're now here, come to us. And it's worked well for firms like Davis Polk. Cleary, who don't even have a Silicon Valley office, have one of the most successful corporate practices of any New York firm in Silicon Valley because they've simply developed a good reputation there. So there's a skimming strategy you can execute, but you have to be already elite. And then where people have really floundered is by trying to come into the second circle, where they'll come in and say, well, look, we don't do any of that funny startup stuff, but once your company gets big enough, you're going to need sophisticated legal services, and Wilson & Cooley and those local firms kind of don't really get it, so you need to come to us. And it just hasn't really worked. Because with most companies of any sophistication, they won't change general counsel, they won't change law firm unless either the general counsel changes and therefore brings in new relationships, or someone screws up. So does that answer your question?
Yes, thank you.
Oh, we get to do it again.
Tried to bust through it. Couldn't
All
get
right, so I think we're okay on time. So the secret sauce and the first boom. Do you want to just click it once more so we've got that up? Yeah, so when I first arrived in Silicon Valley in 2000 to join a startup, which was an interesting but spectacularly unsuccessful experience. But it did get me to Silicon Valley just at the end of the first boom. And at that stage, the local firms were just on the crest of a wave. So their numbers were spectacularly better than many of their peers nationally. And the secret sauce they were all talking about, people would say, what's the difference? They say, oh, there's this kind of secret sauce, the idea being that the guys who were in the valley, close to the companies, were able to identify the opportunities, take equity, and the whole thing was this sort of beautiful money-making machine. But that if you weren't in the club, then you couldn't get into the club because you needed market share and flow and relationships. So for a while, that was spectacularly successful. And then the whole issue of taking equity in clients, which of course now, over the last 10 years or whatever, has been subject to great scrutiny and analysis on conflict of interests. At the time, people were just kind of blasting through it. It's whatever, Fred's bought in the next Facebook, he gets 20%, the firm gets 80% of his bid, it's all good. And there was very little analysis done of how all of that would play out. And there were a number of people, lawyers in Silicon Valley, who were just famous for having made $50 to $100 million on a couple of their clients in 98, 99, 2000. Bizarrely, some of them are still practicing law. That's a very strange life decision in my view.
Which I think the fact that it was all done by the seat of the pants. Joe's got a great example on the firing clients piece, because I think that was almost the extreme example.
Yeah. So one of the stories where, again, looking back, you can sort of spot the tipping point. But Cooley had been enormously successful to a point where their corporate partners just had absolutely no capacity. So they made a strategic decision to fire mature corporate clients out of the third circle so that they had space to bring in more companies in the first circle. And there was a huge tussle at the top about how it could possibly make sense to focus less on the companies that have been the traditional gravy train for law firms, to a point where one of the most successful partners in Silicon Valley left. And is still one of the most successful partners in Silicon Valley, but at a different law firm, where he's servicing the same public company clients that he took with him. And Cooley reversed the policy after a while, but it was there for a period of time.
Yeah, I think the other thing is that the boom here led to the first major pay raise for associates. This was back in '98. Gunderson, which was one of the firms that was handling so much of the early stage work, jumped the rate to $125 for first-year lawyers straight out of law school. And that was a watershed moment, because it was about a 25% raise for even the highest paid New York lawyers. That led, if you take it to current day, that led to the jump to 135, 145, 160, which threw law firm economics all out of whack, because so many of the firms in the Am Law 100 tried to chase, and most of them could never come close to affording that. If you take a look at what the swing back of the pendulum, you had to cut a lot of associates, and largely it was because they were just getting paid too much. That was a later stage issue because the jump to 160 was largely to try to keep folks who look a lot like you out of the investment banks, because there was a pull for a small pool of talent. But it all started because it was really rolling in the late 90s in the Valley.
But then,
Until now.
Yeah, so it all kind of came to a fairly spectacular end shortly after I joined my startup. And the bust was precipitous. The investment in the startups stopped virtually for a couple of years. And Brobeck is seen as the sort of interesting case study on law firms that went under at that time. As you'll see on our slide, there are two others that went under since, but Brobeck was, I think we said 2002, whereas the others were more like 2008, although I think the seeds of their destruction were probably sown back in 2002. So are you actually studying anything on about stresses and strains on finances of law firms and why they go bust? Because if you are, I'll spend 2 minutes on that, and if you're not, I won't. No, is the answer. Okay, so if anybody's got any questions about that, I'm happy to answer them, but let's move on. So that was just my point about the firms that went bust in 2008. There were kind of eerie parallels to the stuff that happened in 2002, and it was the collapse of Lehman that then triggered those other two firms to go. So the next thing was, it was helpful for us in our business that Silicon Valley recovered first, because legal recruitment, which is what we do, moving partners from one law firm to another, is a pretty basic business, and you need law firms that are prepared to take risk, and you need lawyers who think they've got business but should be earning more money. And in 2009, none of the law firms wanted to take risk, and none of the lawyers thought they had any business. So it wasn't like our business sort of went down 10%, it went down about 80%, because nothing happened. Whereas, interestingly, the law firms, being clearly much more sophisticated, but also much more multifaceted beasts, were able to come through it, often with their profits dropping 10, 15%, which they were all moaning about. But actually, that was a pretty minor adjustment, given the scale of adjustment in the marketplace.
Yeah. But the 2009 was just a rotten year for everyone. The challenge was you had law firms are obviously set up to handle counter-cyclical issues. So you'd think corporate's bad, litigation will pick you up. But there was a time when there wasn't enough money in the system that companies wouldn't bother to sue because they figured it would cost too much to get anything out of it. So even the litigators were down for a time, but there was after you hit the trough, it started to bounce back. Litigation started to bring it back, and we can touch on
Sure.
Some of the IP wars.
Yeah, in fact, I think we're one click away from the rest of that slide. Yeah, because the things that really helped kind of turbocharge the Silicon Valley market were IP litigation, because the iPhone came out in 2007, and by 2008, everyone was fighting about the patents surrounding smartphone technology. And the amount of money that that's generated for the major law firms is unbelievable. And the amount of interest there is in patent litigation partners with business, they are one of the most sought after special niches in the recruitment market.
Last year, we won't use the name of the firm, one of the major law firms billed in the high 8 figures for one of the smartphone wars.
In 1 year.
In 1 year.
Yeah. And then, again, I don't know, have you studied much on trolls and the effect of troll non-revenue generating entities in patents? Because that's been huge in our industry. There's this array of companies where intellectual ventures is the biggest, the most sophisticated, but basically buying up patents and then suing or licensing the patent rights to generate income for the companies. But it's completely changed the landscape of patent litigation.
So if you take a look at, if you think back to the three circles, you'll see some leaders here that have emerged. Davis Polk clearly has taken hold of the capital markets. There are a few deals that are done, a few IPOs that are done where they're not underwriting. They had a clear relationship with Wilson, and what you see more often than not is press release comes out, Wilson's got the company side representation, Davis Polk's handling the underwriter, and it just rinse and repeat. Kirkland came in 2003 to the Bay Area in a little over a decade, has come to dominate the emerging private equity market. There's a few others, ropes that arrived that have strong private equity ties, but this is the mid-market, meaning the $500 million to $1 billion range on the deal. Simpson still dominates the $1 billion plus, but this was the engine room in the late 2000s, and probably 7 out of 10 private equity lawyers are working at K&E in the Bay Area. San Francisco mostly, though. Skip Latham, because we've talked about the full array. Goodwin, I think, is the big winner when it comes to out-of-town firms, Goodwin Procter, that have come and figured out how to play the big boys game. So if you talk to Wilson, Cooley, Fenwick partners and ask them, who else do you see? It's Goodwin. And you can't say that about anybody else who's come to town. And you have to credit them because they were able to take a risk, carry the risk, hire young talent, and let them succeed. Whereas most firms couldn't do that or weren't willing to do that.
So I'm going to blow through the next slide in about 15 seconds so that we're done by 12:30. But just on firms that have been less successful and why. Milbank, as I'm sure you'll know, is kind of an elite New York firm. Under its previous chairman, the mantra on their strategic differentiator was, we want to be more profitable than anyone else. And by 2006, they weren't making money in corporate and they weren't a leading player in IP litigation. So unlike many firms which just hate closing offices, whether it makes sense or not, they just cut out at that point. And then White and Case was a slightly different story where they had wanted to be on the West Coast. They hired a group of people in San Francisco. When Brobeck went bust, White and Case was struggling to be as competitive as it wanted to be globally, and so that office was small and not growing. They got out of San Francisco in 2006. Perhaps we should save the discussion on IP boutiques again, because if you've got questions, we'll answer them. But there's a interesting, for us anyway, little side alley about how the IP boutique firms have fared over the years and why they're successful and why they go bust. And the strategic differentiator point is just that a lot of the firms that are sort of wallowing around and not going anywhere in the market, you'll go and see them and they'll say things like, well, you know, we've got a really strong office in New York or London or Shanghai, to which most of the guys in Silicon Valley go, well, so what? You know, what difference does that make to us as a client?
Joe made a comment about the Valley being insular. For many, this is not an overstatement. If they couldn't make a long-distance call, it wouldn't make a difference to their practice. So making the comment that we have a strong office elsewhere just doesn't get you any traction.
So we were going to look at kind of the boom that we're in now and why it's different. And one of the first things that's different is just the magnitude of the deals. Because we were looking at when Amazon went public in '97, it was a fairly big, robust company, and it went out at under $500 million of market cap. And then if you look at the deals recently, I'm sure you've read about the WhatsApp deal, but I mean, even the guys in Silicon Valley are going, what the hell happened there? Because there's 35 employees and 19 billion of valuation is pretty wild. And you had the Instagram one.
Yeah, the Instagram, but that was only $1 billion. 2 founders and about 9 employees.
So it's just breathtaking, the size of the deals. Sadly, of course, from the lawyer's point of view, you don't get 19 times as much money on a $19 billion deal as you do on a $1 billion deal. But the fact is, there's just a huge amount of deals around. Do you want to make a point on use of debt?
But there's also an evolution where, going back to Davis Polk finding a way to make a lot of money in the Valley, the companies have grown. Obviously, there's been a generation now between when you had version 1 and today. So larger companies need more sophisticated legal services. Earlier in the year, Hogan Lovells handled with Simpson Thacher I think it was a $17 billion debt deal for Apple. That just didn't exist a generation ago with the companies that you think of. It may have happened with non-tech companies or one like Intel, which was around. But this was the idea of setting up shop for many of the AmLaw 50, which was if we can carry it long enough, there will be a maturation in the companies, a need for more sophisticated legal services, and we can start billing at our top rates. I would say we're not quite there yet, because if I'm making a big deal out of one $17 billion debt deal, it means there aren't a lot of them, but at least it's moving down the track and you can see a logical progression.
So before you click again, how many people are thinking of moving to the Bay Area as lawyers? Okay, you presumably heard a little bit about the cost of housing. So I'd just like you to have a quick look at the next slide, and then you can tell us roughly, well, I'll tell you, this very fine property, by the way, our other researcher, his mother is one of the leading realtors in Palo Alto, so we're all over this topic. But this property is about 2 blocks from downtown and went on the market for $1 million just before Christmas. Would you care to guess what it's sold for? 1.6 million. It's on a 2,700 square foot lot. So anyway, if you need any further encouragement, let us know. But that's.
Can I ask a question, sir? We had a speaker last week who talked a lot about how young lawyers can develop to be better lawyers in law firms when they start out. In your business, you're placing, by and large, partners,
right,
in other firms. And most of the graduates from Harvard Law School are going into big firms, although not all of them do. And most of them go into big law, big corporate law, big litigation. And sometimes they're going to be asked by these partners you're placing, do they want to come with them? And that puts them in a very strange place as an associate. But you advise partners. So how would you, talking to this audience, facing the kind of twists and turns we see in this economy, when they're wildly successful, wildly smart young people who have a number of options, how would you caution them or at least counsel them when faced with a lateral partner moving from one of your big 3-circle firms? Do they tie their wagon to them? Do they think about their longevity in the institution that they're at? Do they think about going to a startup? What would you say to a young associate? Certainly you're talking to the partners, but you're not talking to the associates.
I'd say, thank goodness you went to Harvard and are really smart, because only you can make the decision. But I mean, the fact is, I was blown away when I came here 5 or 6 years ago, and I asked how many people thought they'd end up as partners in firms. And it was some unbelievably low number of the people who started off going to big law firms. So it seems to me that the whole kind of social contract and the idea that you go to firm X, you do 8 years, you become a partner. I mean, tell me if I'm wrong, but it seems to me that that's kind of a possible track, but it's only a possible track, and that many people would jump off in other directions. So to answer your question, I think you should join a law firm because you like the values and the direction and the way that law firm projects itself. But ultimately, if partners are moving around all the time, then clearly you've got to do what's right for your career. If the partner who runs your practice group comes into your room and says, I'm moving with 3 other partners and 8 associates and I want you to be one of them, then no one's better placed than you to know whether that's a smart thing to do, because you're either going to think, thank God he's going, the guy's an idiot and I hate him, in which case it's just good news because you can go and work for someone else. Or you can think, well, actually, it completely makes sense that he's moving us from this firm to a firm that's got New York, London, China, more IP, whatever it is, because I can see, firstly, that's going to give me better work, and second, it's going to give me better career development potential. Yeah. So I don't think we can say any more than that.
Yeah, I would focus on where your work comes from. If you're a junior lawyer, your utility is in doing someone else's work and learning from that until you can create your own work. So if the person who puts work on your desk is leaving, you have to weigh that, because unless you feel pretty confident that work's going to come from other sources within that same firm, the story that played out when and continues to play out, but when times got hard and partners left their associates behind, the next day the analysis goes up the chain to management. how do we keep these associates at 80, 90% utilization? And if they can't, they're the next ones to get hit. So you have to look out for yourself.
Yeah, and I think the other point is the sooner you can get away from the who feeds me work idea to how quickly you're building your own practice, the better. Because the people who make partner in the firms are no longer necessarily the best lawyers. They're the best all-round package of good enough at the law, excellent at the client relationships. If we don't make them a partner, who knows what's going to happen to that practice area. So it's very much the package that you need to be developing. In fact, one of the Magic Circle firms in England, which will remain nameless, said, we've got this new really radical strategy. We're going to try and hire lawyers who are better with people. It's just like, wow, that's just fantastic. This was last year. So I think we should skip the next one about the companies. And again, if you want to know about Nest, come and talk to us afterwards. And then in terms of the stuff that's hot for Silicon Valley going forward, of course, they love the buzzwords. But the NPR study was, just for me to ask you a question, which there was a huge study they were talking about recently about kind of graduates from Ivy League schools and the extent to which they are looking at moving to Silicon Valley rather than going to Wall Street. And it was kind of focused mainly on investment banks. But how many people, how many of you are more interested in moving to Silicon Valley than Wall Street, if that's the right way to phrase the question? So how many Silicon Valley and how many Wall Street? Yeah, so I mean, that's pretty stark, isn't it? That's good for our house prices. So in terms of the practice areas, we're hearing a lot about EPS, electronic payment systems, because the explosion, obviously, in trade on the internet means an explosion in legal issues around protection of data, protection of information, risk on trades. And there aren't really that many lawyers who know anything about it. So it's an industry that if you're looking for kind of what's currently X million of legal revenue and will soon be 100X, then that's obviously one such area. SaaS, software as a service, all of the companies in Silicon Valley are talking about everybody's renamed themselves blah, 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 cloud solution. And so lawyers who are experts in anything pertaining to moving your business into a cloud-based environment or selling and buying cloud-based systems and server farms, that whole area is very hot and very under-lawyered. I won't ask you to say anything if you've dropped your microphone in. Do you want to talk about any of the other areas?
No, you covered them.
Yeah, I mean, data privacy has been around longer, but obviously ties in very much to EPS. Intellectual property remains very hot, although the patent prosecution side of things is getting shoveled off into smaller firms or lower cost firms. And the big money is in the patent litigation and then what the firms call TTL, so technology transfer and licensing, which again, it's super busy. And antitrust is a perennial favourite. So we'll stop there and hopefully leave a few minutes for questions if you have any.
Going back to the three circles, you were talking about client retention between first and second circle and basically the difficulty of coming in at the second circle level. Is the client retention similar between second circle and public firms? And does that pose a problem for Silicon Valley firms, particularly those like Fenwick that are coming in at the front end to try and realize the potential gains in the long run?
I'm only laughing because the one of the more publicly discussed mergers recently was Orrick and Pillsbury were talking to each other. And one of the reasons that they were talking to each other was because they felt that together they had a much stronger coverage of the three circles. So Pillsbury was, a long time ago, one of the most venerable firms in San Francisco, very strong first circle public company practice, has some early stage, but it's not as diffuse as the Orrick practice. Orrick, very strong on the early company stage, much less strong on the first circle. So the idea was if they put them together, you could ensure much stronger client retention as the companies matured. But to answer your specific question, I would say it's much easier to hang on to the clients between the first and second circle because it's not such a bright line. They're a bit bigger, the issues are a bit more complicated. But when the company's looking at either an IPO or a kind of one-off, how do we maximize value M&A transaction, they will quite often beauty braid other law firms who will almost always say, well, actually, we've done 100 of these and we can run it much more efficiently than the value firms. Any other questions? Gentleman in the pink shirt, if I may call it pink.
I'm considering taking the patent bar, and I'm just curious how useful of a credential you think that is for success in this world you're speaking of.
Do you want to take that?
Yeah. Just to define it, you're going to take the patent bar. Is that to do patent prosecution work, or are you thinking that would be an extra feather in your cap to tackle IP litigation?
I have no idea.
Okay. It's hugely useful because it differentiates you in a market. It's almost impossible to do patent prosecution without the patent bar. But on the litigation side, when companies look at the team, they're almost always requiring that a percentage of the team has a patent bar license because they figure that they can speak the language of the engineers. So yeah, it's going to be very useful to you.
So how are the first circle firms competing right now, and like how are they trying to differentiate themselves amongst each other? And the second question is, so when the startup actually, tries to decide which firm to take, what did it look at?
Right.
So
So,
crack at it.
yeah, thanks, because that's a lot harder than the last one. As between the established first circle firms, they simply differentiate on brand. So if you're a successful entrepreneur, you may already have friends who've got views on Wilson or Fenwick or Cooley, and you will naturally get pushed towards one of them, but they're all excellent in that space. If you're trying to differentiate, maybe we can go back to the first circle slide, but if you're trying to break into that market, which I think maybe was part of your question, first of all, as Daren said, you need scale. So Oric ended up with scale because there was a firm that the name flashed up, Venture Law Group, which was initially a very high-end boutique just doing first circle work, but about 40 of their lawyers ended up en masse at Oric. So Oric instantly had a first circle brand. But most of the, going back to the insularity point, Silicon Valley still works on a relationship basis. So the chances are your lawyer for your first circle startup company will be the guy whose kid goes to school with your kid in elementary school, you play tennis together, whatever. It's just a network. And so that's generally how those early stage company lawyers develop their practices.
I'll say that the branded firms, the Wilson, Cooley, Fenwicks, they trade on when it comes to going out and having creating a new relationship with a new entrepreneur that has an early stage company. They're trading on their relationship, their established relationship with the venture capitalist. If you're not playing with that brand, a lot of them are trading on cost, their willingness to I'll work harder, or I'll take maybe a bit of equity because I don't have some of the limitations that my larger firm friends over there have. And just price. The Valley has run into the challenge of how do you price early stage work, especially when a lot of the work is now just being uploaded by Wilson and Oric into forms, and they'll charge you a flat rate, or you could just access it directly. Because they know that's not going to make them a lot of money. It's getting the second round and third round and mezzanine round money. That's where they start to be able to charge, because there's money in the system that they can get for their fees.
Yes, ma'am.
I was wondering, you mentioned boutique litigation, patent litigation firms. How did those fit into the picture that you're describing?
So the short story on that is, way back in time when the dinosaurs roamed the earth, the patent lawyers worked in patent firms because it was seen as kind of geeky and weird and didn't make any money, and who cared. And then as it became an area that the big firms realized they could make money in, they either hired groups of people from those firms or they took over those firms, integrated them, started making lots of money. But what's now happening is the big firms are saying to the prosecution guys, either you don't make enough money or you create too many conflicts, go away. So there's prosecution boutiques being set up. And then the patent litigation guys are making huge amounts of money. But recently, within the last 18 months or so, 2 of the biggest guys have left to set up boutiques, but they're boutiques representing the adversaries who have repeat. I mean, it's not just the non-performing entities, but they've got businesses where they're trying to take on the patent litigation, earn huge amounts of money in their boutique, basically suing the guys who are defended by big law. So they just are they gamekeeper turned poacher? I think they are, aren't they? Rather than
I'd say it's analogous to watching a U.S. attorney, turn around and defend for a lot more money in a large firm. So the 2 people that Joe's talking about are Matt Powers, who was a titan for IP litigation for a while in Silicon Valley. It was really his office for a long time. And a gentleman named John Damaris at Kirkland & Ellis. Damaris did it first, and then Powers did it probably about 6 months later. And there's a question whether or not that window has already closed.
Right.
Whether that's still a profitable choice for people. But at least for Damaris, it was a question of somebody making a lot of money, leaving to make an obscene amount of money.
Any other questions? Yes, sir.
This is probably from a different perspective, because I'm not a lawyer, but I'm interested in the antitrust and mergers and acquisitions perspective and tax havens. Okay. Do you have an estimate personally, or either of you, of how much of Silicon Valley capital is ensconced in tax havens?
Daren. I'm just passing the question to him. That's way too difficult for me.
Well, it's not difficult to say I don't. I don't have a say.
This is more the issue of use of Ireland as a tax haven and Google and Starbucks and everybody else offshoring their money, is that?
Exactly.
Yeah. No, because that's kind of beyond our pay grade. We focus very much on Silicon Valley and the law firms there. I mean, it's obviously a huge issue. Interestingly, it seems to me people in America care about it 1%, people in England go nuts about it. So I don't know why there's this mismatch currently. But we should talk about that separately, maybe.
You mentioned patent litigation several times. What's the market for patent arbitration and in general arbitration market? I know it's not a big deal in...
Oh no, I love arbitration. I've been doing mainly arbitration for the last year, but I'm just not quite sure. When you say patent arbitration, I don't know what you mean.
Just arbitration procedure related to IP.
Oh, okay. Okay, so generally speaking, arbitration is a white-hot practice area, partly because of China, because nobody wants to litigate in China. They all want to arbitrate, and a lot of other countries, Russia. So that industry has gone, again, it's almost like IP. It's gone from being kind of geeky and weird and done in Paris to being this incredibly important mainstream practice area that all the firms are piling into. Patent arbitration is kind of at the next stage of evolution of that, because I think if I understand your question correctly, it's coming because people would rather arbitrate in the patent world than sue each other.
So it's growing, right?
So, absolutely it's growing. But nobody has yet asked us for a patent arbitrator. But I can't imagine that it'll be, in 5 years' time, I'm sure they'll be highly valuable. So I'll write that down and use it in my next talk. Thank you.
I was just curious, thinking about, as first-year associates leaving school, is it a common trajectory for people to start in the patent litigation firms and then move to the bigger firms, or do you generally see people more starting in the bigger firms and then going to the boutiques from there? Like, how does that, is there sort of a common...
At that stage, it's a swinging door. It's really just about getting good experience.
But I think if I...
To do either one or the other, would you be limiting yourself by choosing one as opposed to the other?
For your first summer?
No, not first summer, but for like as a first-year associate.
Oh,
for your first job.
Got it.
I would have, if you had a choice between big law firm with excellent reputation in IP and smaller patent litigation boutique, I would start with the big law firm because I think they're much harder to get into. And I think, well, sorry, I delete that, especially as this is being recorded. I have no idea how hard it is to get into a specialist patent litigation boutique. But I think if you're trying to make partner in a big law firm and you're 4 or 5 years in and you've been there since you started your career, you've got an infinitely better chance of making partner than somebody who laterals in at 5 or 6 years qualified. So if that's part of your focus, I'd start there. And I think there will always be a broader array of opportunities to move out after 3 or 4 years.
I agree. Time for one more question. Good? Well, thank you. Well,
Oh.
I was going to say, when you're recruiting partners to come work in Silicon Valley, where are you mostly taking them from? Is there a real East Coast, West Coast divide?
No. So 99.999% of the recruitment we do of partners in Silicon Valley is of other partners in Silicon Valley. So it's very insular. There are, in my 10 or 12 years of doing this, there are 3 or 4 examples of people who were very successful in Chicago, moved to Silicon Valley and have been very successful. But generally, up until this point in time, the lawyers have generated local relationships and local business, and you move them around. I hesitate only slightly because obviously with the fact that so much work is now done remotely and people don't know where their lawyer is, I would guess that could change, but it hasn't changed yet.
Silicon Valley is still a state of mind in some respects. It's very difficult to be a trained New York lawyer who had mid-circle experience and then parachute in, because it'll be a foreign language for the first set of months or year. So it's not that we're pulling people in. It's a game of musical chairs, in essence. One comes from here, and you leave an empty chair, and the next one gets filled. So maybe I think that probably answers it.
Daren and Joe, thank you so much. We'll be here for a few minutes if you want to ask them questions, and they'll be headed back up to our office on the 5th floor.
Thank you.
Thank you.